address is the applicant's motion in limine. There are, I believe, 4 points. Is there any resistance on behalf of the state?
Good morning, Your Honor. I'm just taking a look through it again just to make sure, but I don't believe we have any resistance on that, and we would join the motions as well. Obviously, any undisclosed testimony from their experts, hearsay, things of that nature, we would agree that the rules of evidence and civil procedure control on that.
Thank you, Mr. Bakke. The applicant's motion in limine then will be granted in its entirety. Counsel for the applicant, did you desire any further record on that motion for any reason?
No, Your Honor. Ms. Erica Nichols-Cook on behalf of Mr. Mullis today, for ease of the court reporter, we don't need an additional record.
All right, thank you, Ms. Nichols-Cook. Any other preliminary matters then that counsel wishes to address? Ms. Nichols-Cook?
Your Honor, we briefly talked off record about some exhibits. We're still talking to the state about that, and we will update the court on the next break. And I think we would request to do a short opening statement, but we don't have anything else preliminary.
Any preliminary matters that the state wishes to address?
No, Your Honor, I would agree with that recitation of our understanding.
Okay, Ms. Nichols-Cook or one of your co-counsel, if you're ready to proceed with your opening, you may do so.
Yes, Your Honor, Ms. Thompson is going to do the opening.
Ms. Thompson, whenever you're ready.
Your Honor, with the court's permission, I'll stand just for this opening portion of the proceedings today.
Certainly.
Good morning, Your Honor. Todd Mullis has always believed that his wife, Amy Mullis's death was a tragic accident. He always believed this because he was on his family farm the day that she was injured. He was there right after his son, Tristan, found her. He was there as he and his son, Tristan, tried to give Ms. Mullis emergency aid and rushed her to where EMTs could get her to the hospital. He was there when first responders treated her injuries like they were the result of an accident. And he was not aware of any information that would tell him that what happened to her was anything other than an accident. Even when police began an investigation and began to treat him like a suspect, he did not stop believing that what happened to Ms. Mullis was an accident. He knew he had nothing to do with her death, and he didn't believe that there was any evidence that anyone else did either. His account of what happened and his beliefs, unlike the accounts of some of the people that you're going to hear in this post-conviction trial during this week, has always been the same. But at trial, he did not have any way to present evidence to the jury that this was an accident. And that issue is what the court's going to hear about over the course of this hearing. The court's going to hear evidence that he begged his attorneys, begged them all through pretrial preparation to investigate this case as an accident. The court's going to hear evidence that his lawyers disregarded what he was telling them. The court's going to hear evidence that his lawyers did not talk to experts or fact witnesses that would have helped them understand and present a case that this was an accident. And the court's going to hear evidence that his lawyers did not listen to his explicit direction to investigate these issues and to pursue this case as an accident. And because his attorneys did not listen to him, because his attorneys did not investigate or present these issues, the jury did not hear important evidence that they needed to hear to understand that the state's case was simply wrong. The jury heard the exact opposite of what Todd Mullis asked his lawyers to present. They heard his own lawyer in opening statements tell the jury that Todd didn't know what he was talking about, that Ms. Mullis was murdered. They heard his own lawyer, in effect, tell the jury that Mr. Mullis was not credible. They heard his own lawyer make these concessions on day one, right when this trial began, and then really have no defense to present on Todd's behalf. His lawyers conceded guilt in this case without any plan to present another defense. The court is going to hear evidence that Todd didn't agree to this plan. He didn't know this was the plan. He'd actually asked his attorneys to do the opposite. And at this point in the proceedings, the court has heard in various pleadings at other hearings that we've had, the PCR team for Todd repeat this to you over and over again in all of the filings, that this was an accident, that this is what this case is about. And we've repeated that to the court because it's true. And it's among just the many reasons that Todd Mullis deserves a new trial and what this court is going to hear at this hearing. On behalf of Mr. Mullis and his team, we're grateful that after all this time that Mr. Mullis is able to be in court this morning to remedy this wrong. Nobody listened to Todd at trial, but this week he'll have an opportunity to be heard through this case. And the court is going to hear other important evidence as well that the jury never heard, that is going to create at least the reasonable probability that the outcome of his trial would have been different if the jury had heard everything that the court is going to hear over the course of this trial. The court also knows that this is the rare PCR case here in Iowa with an actual innocence claim. And that is what the court is going to believe and know about Todd after this hearing. The court also knows that all of Mr. Mullis's most important claims survived the summary judgment rulings that the court made, and that the court is going to hear his claims and his evidence this week. And everything that this court is going to hear is going to establish that the underlying trial that Todd had was nothing short of fundamentally unfair. It was unfair because of the actions that his trial counsel failed to take, that any reasonable attorney would have done on Todd's behalf. It was unfair because the state withheld from Todd important favorable evidence that would have undermined confidence in the outcome of this trial. And it was unfair because the trial prosecutors did things that resulted in misconduct in how they presented the case and what they presented. And the court's going to hear evidence that makes clear that Todd Mullis was right. As we said, the court will hear that Todd's attorneys conceded right at the beginning of this trial that this was a murder. And with that sort of tent pole in the state's case, the state killing the jury and nobody disagreeing that Ms. Mullis was murdered, that resulted in a situation where there was really no meaningful adversarial testing of any of the evidence that the state presented. And the court's going to hear evidence about each of these issues this week. The court is going to hear that the state then was allowed to present witnesses giving contradicted hearsay and innuendo that painted Todd in a bad light. The court's going to hear that that evidence painted a false image of Todd, of his marriage to Ms. Mullis and his family, and that made random Google searches that were done by a family with a house full of teens and preteens seem like evidence that Todd was planning to harm his wife. The court's going to hear the truth about those searches this week. Without Dr. Cruz, the state's main witness, telling the jury that this was a murder, that evidence is what it is, which is kind of silly, meaningless, evidence that really doesn't explain to anyone what happened to Ms. Mullis. The court's also going to hear from fact witnesses that have important details that help us understand what experts that the court is going to hear from this week are going to say, which is that Ms. Mullis's death was an accident. The court will hear from first responders and from other people through depositions and through live testimony who witnessed medical efforts for Ms. Mullis. The court's going to hear from those experts that I mentioned that are going to explain from a variety of disciplines how all of the objective evidence in this case demonstrates that Ms. Mullis's death was an accident and that the testimony that Dr. Cruz told the jury in this case was just wrong. The court is going to hear, either live or through depositions, from Todd Mullis's trial counsel. And the court is going to learn about the mistakes that they made and that those mistakes were not about strategy. They were just mistakes, things that were just wrong and cannot be explained by any strategy. The court's going to hear from an expert, Sean Castle, who's going to explain that the family's Google search history and electronic data from their home is exactly what it appears to be. Google searches from a family, from teens, from preteens that are using Google to search for things, sometimes random things, as we would all expect teens to do. And the court is also going to hear from depositions, from documentary evidence that makes clear that anything that anyone testified to about at trial about Todd is going to be a product of them being told that their friend was murdered. And believing their friend to be murdered made statements that were hearsay, that were innuendo, that don't aid in understanding what happened to Ms. Mullis at all. I want to say one final thing about the evidence that the court is going to hear during this trial. Mr. Mullis is here today because the state made the Mullis's private family tragedy public. And I say this because Mr. Mullis is here, his children are here, members of his family are here, and certainly for Todd and his family, they would have preferred that the investigation into Ms. Mullis's case was private, and that their family's privacy was respected, and Ms. Mullis's privacy was respected. If that had happened and the authorities had made the right decisions in their investigation, then he would not have needed a public hearing like the one today to get the justice that he would deserve. And it is truly unfair to Mr. Mullis, to his children who are sitting here today in support of Todd and his innocence, to have this be the forum to discuss the issues in this case. And I say that because the court, over the course of this week, is going to hear scientific evidence that is going to be difficult for this court to think about and to hear and to see. And as Todd's attorneys, and on Todd's behalf, we're going to do the best we can in our presentation to respect Ms. Mullis's privacy, to respect the tragedy of her death, but it's going to be difficult to do that in light of the evidence that we need to present, because Ms. Mullis's private medical information is going to be the subject of this hearing, her privacy in terms of her body, her privacy in terms of the detail of her death and her medical history, those are going to be made public during this hearing. Her private life. Everyone has things that are appropriately private about their life that shouldn't be the subject of a public hearing, but we're going to have to present and hear about some of those things this week, and present them in a public way that Ms. Mullis and the Mullis family don't deserve. This is not how Mr. Mullis would choose to have this resolved, but that said, because this is the evidence that the state relied on to charge him, because it's the evidence that was wrong, that was relied on to convict him, because his lawyer was ineffective in combating all of this evidence, all of the errors at trial that led to us to be here today, this public venue is the only way that Todd can achieve justice, and that's why he'll be presenting about these issues this week, because he does deserve a fair trial, a trial where the jury hears the truth about what happened, a truth that's grounded in science and that's grounded in what knowledgeable, experienced professionals have to say about what happened to Amy Mullis and what those knowledgeable professional experts concluded about the facts of this case. That's what this trial is going to be about, Your Honor. And at the end of this hearing, the court is going to agree that Todd's trial was undeniably unfair. If the state chooses to retry Todd after this hearing for what science tells us and will tell this court was simply not a homicide, then a jury deserves to hear the truth at a fair trial where everything is going to come out from knowledgeable, experienced people that will allow the jury to know the truth. And at the end of this hearing, Your Honor, the only just outcome will be to grant Todd Mullis a new trial. Thank you.
Thank you, Ms. Thompson. Counsel for the state, did you have an opening you wish to present?
Briefly, Your Honor. Thank you.
Whenever you're ready, Mr. Duden.
Thank you. Good morning. My name is Josh Duden, along with Thomas Bakke and Scott Brown. I represent the state of Iowa in this post-conviction relief proceeding. As the court knows, Todd Mullis was convicted in September of 2019 for first-degree murder by a unanimous jury for causing the death of his wife, Amy Mullis. The Iowa Court of Appeals affirmed that conviction later on direct appeal. And here we are in a post-conviction relief proceeding which Mr. Mullis has brought and commenced to attack his conviction again. The evidence will show, and the evidence has in fact already shown, that Mr. Mullis took the stand at the underlying trial and agreed that Amy Mullis was murdered. He agreed on cross-examination that somebody took a corn rake and stabbed Amy Mullis in the back 2 or 3 times. He agreed on cross-examination that he actually knew this wasn't an accident. And yet we are here today to ensure justice and a fair trial occurred. The evidence will show that sufficient evidence still exists to support the murder conviction of Todd Mullis's murder conviction. The evidence was enough for the Court of Appeals to affirm it, and the evidence will be enough for the court to deny this post-conviction relief application in its entirety. Many claims are brought pending before the court right now, but the important evidence was presented at trial. And a shrapnel shot approach, or a shot in the dark, in a way, is not a way to hit the mark here. The evidence will show certainly that expert testimony will not be enough to attack what the evidence actually showed at trial, in what has already been upheld on appeal, and that's that Todd Mullis murdered his wife, Amy Mullis. And so at the end of this, the state will ask the court to deny his post-conviction relief application and let his conviction stand to ensure that a just trial had occurred already, and find that his conviction of first-degree murder should stand. Thank you.
Thank you, counsel. Are you ready to call your first witness?
Yes, Your Honor. The applicant will call Carrie Pierce. Your Honor, is the court's preference that exhibits be put on the screen for everybody and the witness to see?
We can do it that way if you have them on your computer.
We do.
Okay.
I know, I feel like you also have to allow or hit a special buttons.
I do. Let's see if we can get that rolling. Go ahead and have a seat. Ms. Piercebacher, if you want to pull that screen up in front of you just a little bit, because that's where the exhibits will display for you.
Okay, thank you.
Okay. Can you see the attorney? Yeah,
I can.
Okay, and you can adjust that so that
Okay.
it's not blocking you entirely.
Okay, thank you.
All right, and I'll swear you in.
Okay.
All right, you've been called as a witness. If you'd raise your hand, you've been called as a witness. Do you swear the testimony you're about to give will be true and correct?